Hi, we're reporting live from Freedom 661 and reporting the case on Cohen versus California. This case is about a 19-year-old department store worker who expressed his opposition to the Vietnam War by wearing a jacket with "Fuck the draft, stop the war." The young man, Paul Cohen, was charged with under the California statute that prohibits maliciously and willfully disturbing the peace and quiet of any neighborhood or person of festive conduct. Cohen was found guilty and sentenced to 30 days in jail. The defendant was convicted under California law for wearing a jacket that had an F, the draft, outside the municipal courthouse during the Vietnam War. The defendant did not threaten or engage any act of violence. The state court affirmed his conviction, holding that offensive conduct means behavior which has tendency to provoke others to acts of violence to in turn disturb the peace. The First Amendment to the United States Constitution prohibits the making law any respecting the established religion, independent free exercise of religion, abriding the freedom of speech, infringing the freedom of press, inferring with the right of peacefully assemble or prohibiting the petitioning for government redress of grievances. It was adopted December 15, 1791 as one of the 10 commandments to constitute a Bill of Rights. The issue of this Cohen versus California case, whether California can excise it as offensive conduct when particular scores effort from the public discourse, either upon the theory of court below that is inherently likely to cause violent reactions or upon a general assertion that the states, acting as guardians of the public morality, may properly remove this offensive word from the public vocabulary. Two,
Because no individual actually or likely to be present could reasonably have regarded the words on appellant's jacket as a direct personal insult. Finally, the court was unwilling to give credence to the idea that the government could suppress the type of speech at issue here in order to protect the public at large. Thus, Harlan's arguments can be constructed in three major points. First, states California cannot censor their citizens in order to make a civil society. Second, knowing where to draw the line between harmless, heightened emotion and vulgarity can be difficult. Third, people bring passion to politics, and vulgarity is simply a side effect of free exchange of ideas, no matter how radical they may be. Reasoning of the court. Majority. Harlan based the majority opinion on a vision of the First Amendment as protecting the marketplace of ideas. If they might be expressed at times, he argued that the slogan on the shirt should be evaluated as speech rather than expressive conduct, thus triggering a higher standard of review. Finding that no categorical exception to First Amendment protection applied, Harlan stated that the slogan was not obscene or a fighting word because it was not directly targeted at anyone in the area. He found that the law was overly vague in describing the conduct that it prohibited, and that virtually any law that criminalized the slogan on the shirt should be unconstitutional except for time, place, and manner restrictions unrelated to content. The dissenting. Disagreeing with the majority's classification of the slogan on the shirt as speech,
go.
the First Amendment, as applied through the 14th, prohibits states from making public display of a single four letter a criminal offense, without more specific and compelling reason than a general tendency to disturb the peace. Court of Appeal of California reversed. This concludes the reasoning of the court, and we are part of Freedom 661. The decisions of the court by a vote of 5 out of 4 per Justice John Marshall Harlan II overturned the court's ruling. First, Justice Harlan began by emphasizing that this case concerned speech and not conduct. Harlan stated that any attempt by California to abridge the content of Cohen's speech would be no doubt unconstitutional except in a few instances. Like, for example, if California was regulating the time, place, or manner of Cohen's speech independent from the content of the speech. Second, Harlan also expressed the concern of the court that Section 415 was vague and did not put citizens on notice as to what behavior was unlawful. Indeed, the words offensive conduct alone cannot be said sufficiently to inform the ordinary person that distinctions between certain locations are thereby created. Third, the mere use of untoward four-letter word did not place the speech in a category of speech that was traditionally been subject to greater regulations by the government, as in Roth versus United States, for example. Similarly, Harlan and the court refused to categorize the speech at issue as a fighting word under
Hello, I'm Giovanni Cruz and I'm reporting for 661 Freedom. No judgment of the lower courts reversed. Defendant's speech is protected by the First Amendment of the United States Constitution. The only conviction that the case sought to punish was communication. Thus, this case rests solely upon speech. The state lacks power to punish the defendant for the content of his message because he showed no intent to incite disobedience to the draft. Thus, the conviction rests upon his exercise of the freedom of speech and can only be justified as a valid regulation of the matter in which he exercised that freedom. This is not an obscenity case because his message is not erotic. This message does not involve fighting words because the message does not direct at any person. Further, the public is free to avert their eyes from the distasteful message. His message constitutes emotive speech because it is to seek attention from the public. This speech is protected by the First Amendment Constitution. His conviction must be overturned. Hello, we're reporting live from Palma High School, and we are here to interview Abigail Rios on the case Cohen versus American. So, Abigail, what do you think?
I don't think he did anything wrong. He has freedom of speech.